He walked into that hearing room with the kind of composure that only comes from years of high-stakes legal work. Tailored suit, measured expression, a leather folder of prepared remarks sitting squarely in front of him. Melania Trump's attorney had testified before powerful bodies before. He knew how to handle a committee. He knew how to answer questions without really answering them, how to fill the air with language that sounds cooperative while giving away nothing that matters. He had done it before. He was prepared to do it again. And then Jasmine Crockett leaned into her microphone, and in the span of about 4 minutes, everything he had prepared became completely irrelevant. By the time she was done, the attorney was sitting very still, his folder untouched, his carefully constructed composure showing the first real cracks, and every person in that hearing room was looking at him, waiting for an answer he clearly did not have ready. This was not supposed to happen. And the fact that it did is still shaking Washington. Stay right here because we are breaking down every detail of how it unfolded and why it matters far beyond this single hearing. If you are not subscribed yet, hit that button right now and like this video because this is exactly the kind of moment this channel exists to cover. To understand what made this moment so explosive, you have to understand what this hearing was actually about and why Melania Trump's attorney was sitting in that room in the first place. The hearing had been called to examine a series of questions surrounding financial arrangements and the use of certain official channels in ways that had raised flags among committee investigators over the preceding several months. These were not simple questions. They touched on areas where legal, financial, and political considerations all overlapped in complicated ways, the kind of territory where skilled attorneys are very comfortable because that complexity is usually their greatest protection. The more complicated something looks, the easier it is to suggest that any apparent problem is simply a misunderstanding of a genuinely complex situation. The attorney representing Melania Trump had been called to testify in his professional capacity regarding specific matters related to that investigation. He arrived with a clear strategy, one that experienced legal observers recognized immediately. Acknowledge the complexity. Emphasize the legitimacy of all actions taken. Cooperate in tone while limiting in substance. Make the questioners work for every single piece of information and give them no clear thread to pull that would unravel anything larger. It is a strategy that works very well against certain kinds of questioners, against people who are working from a prepared list and who stick to it regardless of what the witness is doing, against people who are more interested in performing scrutiny than actually exercising it, against people who have not done the deeper reading behind the surface questions. It does not work against Jasmine Crockett. The early part of the hearing went more or less according to the attorney's plan. He was polished and professional. He answered the questions that were put to him in a way that was technically responsive without being meaningfully informative. He deployed the language of legal process beautifully, citing confidentiality concerns, noting the limits of his ability to speak to certain matters, framing ambiguities in the most favorable possible light. Several committee members worked through their questions and got more or less what he had prepared to give them. Then it was Crockett's turn. She did not start the way he expected. She did not begin with the area of inquiry the previous questioners had been working through. She started somewhere else entirely. She asked him a question about a specific document, a document that had come into the committee's possession through a separate channel of the investigation, a document that was not the center of the hearing's stated focus, but that connected to it in a way that was not immediately obvious unless you had read everything very carefully. The attorney's expression shifted almost imperceptibly, just enough for the cameras to catch, just enough for the other members of the committee to notice. He asked her to clarify which document she was referring to. She named it, specifically. With the date it was created, the parties whose names appeared on it, and the specific section she was interested in, she had clearly read it, all of it, including the parts that were not being discussed anywhere publicly. The attorney said he was familiar with the document. Crockett nodded and moved directly to her first question. The question was about a specific representation that had been made on behalf of his client in a prior official communication. A representation that, when placed next to the document she had just referenced, created what she described as a material inconsistency. She laid out the inconsistency clearly and without drama. She named the prior communication. She named the specific language in it. She named the specific language in the document. She asked him to explain how both things could be true simultaneously. The room got quiet. The attorney began his answer with a sentence about the importance of understanding the full context of any legal document. It was a good opening because it sounded reasonable, and it bought him a few seconds. But then he had to continue, and continuing meant either addressing the inconsistency directly or visibly not addressing it, and both of those options had consequences. He chose a path that threaded between them. He suggested the two documents were addressing different aspects of the same situation and that the apparent inconsistency dissolved when you understood the distinct purposes each document was serving. He was smooth about it, experienced. He made it sound almost convincing. Crockett did not move on. She said she understood his answer and asked a follow-up that was more surgical than the first. She took the specific explanation he had just offered, the distinct purposes argument, and asked him to identify, in his own words, what the distinct purpose of the prior official communication had been, given that the plain language of that communication appeared to directly address the same matter as the document she had cited. He was being asked to defend his explanation by being specific about it. And being specific about it would either require him to contradict what was plainly written in one of the documents or to acknowledge that his explanation did not hold. He took a breath, just one, measured and controlled, but visible. His answer was longer this time, more technical. He introduced distinctions between legal concepts that were real distinctions, but that required significant background knowledge to evaluate. He was doing what skilled attorneys do when the ground gets difficult. He was adding layers, making the terrain more complex, hoping the questioner would lose the thread in the thicket. Crockett did not lose the thread. She had the legal background. She had spent years as a civil rights attorney understanding exactly the kinds of distinctions he was drawing and exactly when those distinctions were substantive and when they were rhetorical. She listened to his full answer. Then she said, with complete composure, that she appreciated the technical detail, but that the distinction he was drawing did not appear to be recognized in the specific regulatory framework that governed the communication in question. She named the regulatory framework. She cited the relevant section. She asked him whether he agreed that the framework she had cited applied to this situation. He said the regulatory question was more nuanced than a single section could capture. She asked him which additional sections he believed were relevant. He named two. She said she had read both of those sections and asked him to walk her through how either of them altered the inconsistency she had originally identified. The attorney was very still for a moment, the kind of stillness that is not calm, the kind that is the visible surface of something working very hard underneath. He said that these were matters that would require a more thorough legal analysis than a congressional hearing permitted. Crockett said she understood. Then she said that based on the record as it currently existed, including the two documents she had referenced and the regulatory framework she had cited, the inconsistency she had identified remained unresolved. And she asked the committee chair to note that for the record. The chair did. And in that moment, something that had been presented as complicated and ambiguous and requiring more context became, officially and permanently, an unresolved inconsistency in the public record. Crockett had not proven anything beyond what the documents showed. She did not need to. She had done something more durable than that. She had made it impossible to pretend the question did not exist. The attorney sat with that, his folder still untouched. His composure still technically intact, but visibly costing him something now. The other committee members were quiet. Some were writing, some were just watching. The press correspondents in the back of the room were not checking their phones anymore. What Jasmine Crockett had just done was a masterclass in a very specific legal skill that most politicians do not have and most attorneys take years to develop. It is the skill of constructing a record, not winning an argument in the room. Not producing a dramatic moment for the cameras, building something in the official record that cannot be walked back, cannot be recontextualized, and cannot disappear into the news cycle. She had created a fix point, a documented, official, permanent fix point in a congressional record that investigators, journalists, and future proceedings could return to. That is the work of a seasoned attorney operating in a political space, and it is remarkably rare. The implications of what she had done began to register in the room almost immediately. Staff members who had been working quietly at their desks along the walls were now watching. Other committee members were looking at each other with expressions that communicated an awareness that this moment mattered in ways that extended beyond the hearing itself. The attorney's own demeanor, maintained with evident professional discipline, had a quality that everyone in the room could feel even if they could not fully name it. He was a man who had come in with a plan and was sitting with the reality that the plan had encountered something it was not designed to handle. He was not destroyed. He was cornered. And there is a meaningful difference between those two things. Destroyed is dramatic and often superficial. Cornered is structural. It means the room has closed in a specific direction, and the exit that seemed obvious when you walked in is no longer there. Jasmine Crockett had cornered him with documents, with regulatory citations, and with the official record. That is a different kind of corner than a rhetorical one. It does not loosen when the cameras go off. The reaction outside that hearing room was immediate and substantial. People who follow congressional proceedings closely were among the first to recognize the significance of what had happened, because they understood the technical moves she had made and what they meant for the trajectory of the investigation. But the moment traveled well beyond that audience very quickly. The clip of the exchange, particularly the sequence where she walked him through the regulatory framework and asked him to identify which sections he believed applied, was being shared widely before the hearing had concluded. What caught people's attention, beyond the political dimension, was the demonstration of a kind of competence that television does not usually provide access to. Legal competence, specifically. The ability to read complex documents, understand the regulatory architecture around them, identify a specific inconsistency, and then pursue that inconsistency through a live exchange with a skilled legal professional without losing the thread or the composure. People who had never thought much about congressional hearings were watching this clip and sharing it because it was genuinely impressive on a technical level regardless of your politics. By the following morning, legal commentators and former federal prosecutors were giving interviews about the specific moves Crockett had made. The consensus was striking in its consistency. She had identified a real inconsistency. The regulatory framework she had cited was correctly applied. The attorney's responses, while professionally delivered, had not resolved the substantive question she had raised. The record request she had made was procedurally significant in ways that could matter considerably as the investigation continued. That last point was the one that kept the story alive beyond the initial viral moment, because this was not just a good television exchange. It was a procedural development with real consequences for where the investigation could go next. Investigators with access to the hearing record now had an officially documented unresolved inconsistency to work from. Journalists covering the investigation had a specific, sourced, on the record thread to pull. The attorney and his client's team now had a specific problem in the public record that a press statement could not make go away. Crockett had used 4 minutes of a congressional hearing to do work that would echo for significantly longer than 4 minutes. The attorney's office issued a brief statement in the days following the hearing. It emphasized the complexity of the legal matters involved and expressed confidence that a thorough review would provide full context for all relevant documents. It did not address the specific inconsistency Crockett had placed in the record, which told its own story. Inside Washington, the conversation among legal professionals and political operatives was pointed and substantive. People who operate in the intersection of law and politics were studying what she had done with genuine professional interest. The specific sequence of moves, identifying the document, establishing the inconsistency, pursuing the attorney's explanation with targeted follow-ups, and then anchoring the unresolved question in the official record was being described by experienced practitioners as close to textbook in its execution. Textbook, but also rare. Because executing it requires a combination of preparation, legal knowledge, and composure under pressure that very few members of Congress bring to a committee table. Most members are politicians first. Crockett is an attorney first. And in a moment that required attorney-level precision, that difference was the whole story. The investigation into the matters at the center of this hearing is ongoing. The documents she referenced are now part of an official record that is being reviewed by multiple parties. The regulatory questions she raised are being examined by legal experts both inside and outside the investigation. And the inconsistency she identified, now formally noted in the public record, is not going away. She accomplished all of that in 4 minutes, without raising her voice, without a single theatrical moment. Without anything except preparation, precision, and the willingness to hold a skilled legal professional accountable to the documents he was being asked about. That is what this moment was, and that is why it is still being talked about. Not because of the drama, though there was genuine drama in the stillness of that attorney and the quiet of that room, but because of the substance underneath the drama. Because of what was actually built in that hearing room that day, quietly, officially, and permanently. Washington has seen a lot of hearings. It has seen a lot of moments. But moments that are also procedural developments, moments that are also records, moments that are also tools for what comes next, those are different. Those last longer. Those matter more. The next move in this story is already in motion. The record has been set, the thread has been pulled, and the people who need to be watching are watching, and Jasmine Crockett is not finished. If this breakdown gave you something real today, hit that like button right now and share this video with someone who needs to see it. Every share helps this channel reach more people, and that genuinely matters. And if you are not subscribed yet, do it right now and turn on the bell notification so you never miss a moment like this one. Because the next chapter of this story is already moving, and this channel will be right here when it arrives. Do not miss what comes next.